Hello friends, in the series on the income tax cases, today we will discuss the case of Mrs. Margrit Goverdhan versus Income Tax Officer. This case has been reported in 458 ITR at page number 91. The matter has been decided by Karnataka High Court and the date of the judgment is 10th January 2023. This case is regarding joint development agreement and this case is related to the assessment year 2009-10 and 10-11. As all we know that nowadays the concept of joint development agreement is very common and a lot of litigation, whether in respect of civil litigation, the builder is not able to deliver the work on time, and whether in respect of income tax or GST, there is a lot of litigation. And the only way of avoiding the litigation is to draft the joint development agreement in a very professional manner. Generally, it is seen that joint development agreement is not there, and if it is there, it is not registered. The clauses are not there properly and it is made just for the namesake. But in this case, the joint development agreement was very well drafted, due to which the assessee was able to get its case through. In this case, the assessee gave its land for making the construction under the joint development agreement on the condition that the 60% of the built up area will be handed over to the assessee and 40% built up area will be handed over to the developer. And the possession was given just for the purpose of development. It was specifically mentioned in the joint development agreement that this possession is only for the purpose of development and not as per section 53A of the Transfer of Property Act. If we go by the definition of section 2 clause 47, which says about the transfer, so to conclude a transaction to be a transfer, it is essential that there should be handing over of the possession according to section 53A of the Transfer of Property Act. When the matter was before the learned assessing officer, he was of opinion that since that the possession has been given, so it is a transfer, and he accordingly calculated the capital gain tax. If we see at the present provisions regarding the joint development agreement, which is only applicable to the individual and HUF, that says that the transfer will be when the completion certificate was there. But these provisions were not applicable to the case of the assessee in hand. And when the assessee filed the appeal before the CIT appeal, the CIT appeal said that since it is not transfer according to section 53A of the Transfer of Property Act and the possession has been given only for the purpose of the development, and the point of the department that the developer can sell the flats because there was general power of attorney, but that general power of attorney was with the condition that the developer can sell the flats only when the building is completed. So saying that there is general power of attorney and the right of alienation has been given to the developer is not correct, because it was with the condition that the building should be completed, the construction should be completed, and it should be handed over to the assessee. So the CIT appeal deleted the addition. When the department moved to the ITAT reversed the judgment of the CIT appeal. So the assessee was before the Honorable Karnataka High Court. The Karnataka High Court upheld the order of the CIT appeal and said that in the present case, there is no transfer as per section 53A of the Transfer of Property Act. The possession has been given only with the limited purpose of development, and there is no direct general power of attorney which is giving the absolute right to alienate with the property. It was with the rider that the developer can alienate with the property only upon its completion and handing over to the assessee. So the Karnataka High Court was of the opinion that if the co-joint reading of all the clauses of the joint development agreement is done, then in that case it cannot be treated as a transfer and capital gain cannot be calculated according to section 45 of the Income Tax Act 1961. At the end of this video, once again I am repeating the name of the case. The name of the case is Mrs. Margrit Goverdhan versus Income Tax Officer, and this case has been reported in 458 ITR at page number 91, and the matter has been decided by Karnataka High Court and the date of the judgment is 10th January 2023.